Good morning, everyone. My name is Maya Luria with TMC for Seniors, and today we are going to finish up our series for the fall on elder law and is a trust right for you? I have Shanelle Schmitz here with me today. Shanelle is with Zach and Schmitz PLC. She is an attorney that focuses on designing individual estate plans and facilitating the financial and legacy goals of individuals and families. She counsels individuals and families on all sorts of estate administration. She also practices elder law and represents clients in probate court and will contests, contested trust administration matters, and guardianships and conservatorships. So we're thrilled to have Shanelle back with us today to discuss about trusts. So welcome, Shanelle.
Thank you, Maya, and good morning. So as Maya was saying, today I'll be discussing whether a trust is right for you. And if you could go to the next slide, please. So this has my contact information, so feel free to reach out to me directly if we're not able to get to all of your questions during the presentation today. And the next slide is a legal disclaimer. So of course, as an attorney, I'm going to have a legal disclaimer. So the legal information presented in this PowerPoint presentation should not be construed to be formal legal advice, nor the formation of a lawyer or attorney-client relationship. If any results are set forth within the presentation, those results are based upon the facts of that particular case and do not represent a promise or guarantee. Please contact an attorney for a consultation on your particular legal matter, and they can give you specific legal advice that pertains to your specific situation. And there are a lot of great attorneys here in Tucson that focus on this area of law. So if you need any references, feel free to call our office. We're happy to help you as well. So the topics today are, what is a revocable living trust? So there are many different types of trusts, but today we're focusing on revocable living trust. And trust design, what does that mean? Who does and doesn't need a trust? And common issues with trusts. So what is a revocable living trust? So a revocable living trust is a private contract with yourself and your family. So you would be the trust maker, otherwise known as the creator of the trust. Sometimes the trust maker is also called a grantor or a trustor. You generally would also be the initial trustee. So you would be in charge of managing, controlling, and distributing your trust assets. And you would also be the beneficiary during your life. Your trust document would name your successor trustees or a list of successor trustees. And that would be who would be in charge of managing your trust assets or distributing them upon your death. In managing would be if you were to become incapacitated and you weren't able to do so on your own. And you can name an individual, such as a family member or a friend, or a professional, such as a licensed fiduciary or a trust company. And the trust provides instructions for your successor trustee as to how to manage your assets if anything were to happen to you or upon your death. And to make a trust work, you have to transfer all of your assets into the trust, which is sometimes called funding your trust. Next slide, please. So during your life, you would be in charge of managing, controlling, or distributing your property. A trust is great for disability planning because in your trust document, you can state that if you were to become incapacitated, you would state who you want to manage your assets if you were to become incapacitated, and you would also provide them detailed instructions for how you want your property managed or controlled for your benefit. And a properly funded trust, along with the general power of attorney, because you should always have a general power of attorney to handle things that a trust may not handle for you. So with a properly funded trust and a general power of attorney, you can generally avoid the need for a court-appointed conservator if you were to become incapacitated. Next slide. So at death, your revocable living trust becomes irrevocable. meaning you wouldn't be able to change it. And at death, the trust provides instructions for how you want your assets to be managed and distributed, and it specifies who you want your assets to be distributed to. And you can also include lots of protections for your beneficiaries. Next slide. So when you're talking about designing your trust, you're tailoring your trust to your specific needs. So again, you would be providing detailed instructions on how your assets are used or distributed, and you can protect your survivor, so your surviving spouse, and remainder beneficiaries. One way to do that is to have lifetime protective trust built into your trust document, and those types of trust can provide creditor and predator protection. So in other words, asset protection for your remainder beneficiaries. And you can have different provisions for each beneficiary. So if you have a son and a daughter, you can have different provisions for your son than you would have for your daughter. And you can also have different restrictions as well. You can include bloodline protection. So that would be to try to keep the assets within the bloodline. And you can also address tax savings within your trust. So right now, the federal estate tax exemption is $11.5 million for individuals. So most people don't have to worry about hitting the federal estate tax exemption, but that is subject to change, and there's a lot of uncertainty right now. We are expecting it to go down soon, and it actually, there is a sunset provision in the current law as well. So it's important to create flexibility within your trust to manage those types of tax laws and those types of changes. Another way to create flexibility in your trust document is to have a trust protector. And this is a fairly new legal concept, and it basically protects your original intent. So it allows for certain changes to be made to your trust once it becomes irrevocable, and it basically protects your intent. So it creates that flexibility that I was discussing earlier, such as with tax laws changing. And in your trust, you can also have divorce and remarriage protection. So some of my clients will have provisions that their surviving spouse would have to get a prenuptial agreement if they were to ever get remarried, if they wanted to continue to receive trust assets. So those are the types of protections that can be built into your trust. Next slide, please. So who does not need a trust? So if your only goal is to avoid probate, a trust is probably not right for you. So there are many ways to avoid probate that are more effective and less costly than just putting together a trust and having to deal with the costs of establishing a trust and then the administration of a trust upon your incapacity or death. Next slide. So here are some examples of who we generally recommend would need a trust. So if you live in Arizona and you own out-of-state property, let's say you own a piece of property in California, it would be a good idea to have a trust in place, because then you could title the property in California into your trust. And also if you own property in Arizona in this example, you would title it into your trust. And it makes it a lot easier for your successor trustee to manage those properties upon your death, and it helps avoid having probates in separate states upon your death. Another example of who we generally recommend would benefit from a trust is if you have any special needs beneficiaries. So if any of your beneficiaries are receiving government benefits for their disability, then it may be prudent to set up a trust and have a special needs beneficiary trust within your trust. It's a lot easier to have that set up within your revocable living trust than to have it set up through a will, because the will have to go through probate court, and you will lose some of the lifetime benefits of having a trust in place, such as the incapacity planning. Another example of someone who would need a trust is if you're concerned about tax planning. So say you do have a large estate and you are concerned about the federal estate tax exemption, or you have concerns that it will go lower and it will affect your estate, then it's important to plan for that in your trust and to have flexibility built within your trust. Another prime example of clients that we generally recommend a trust for is a blended family. So one of the common examples that a trust is really good at dealing with is if you want to provide for your surviving spouse, but you don't want to accidentally disinherit your children from a prior marriage, then a trust would probably be beneficial for you. Next slide, please. So common issues that we see with trusts. A lot of times people don't update their trust and they're outdated. So laws are always changing regarding any law that applies to trusts. There's a lot of changes. One of the examples that I provided earlier is the tax laws, where we are anticipating a change sometime in the future. There is uncertainty about that right now. Trust protector is a fairly new concept. So if you have a trust from maybe 10 years ago, you probably don't have trust protector language within the trust. So it's important to have your trust reviewed every couple of years to make sure that it's the different changes within the law are addressed within your trust. Also, your family situation and asset situation changes over time. So maybe you've gotten divorced, or you've gotten remarried, or your children have gotten divorced, remarried, or you have grandchildren. So those are the types of things that you would want to review your trust to make sure that it's still effective and it still meets your estate planning goals. And also your asset situation changes over time. And sometimes how we deal with those assets, whether it goes into your trust or if it shouldn't go into your trust, those types of things need to be looked at every couple of years. Another very common issue that we see with trusts is that it's not properly funded. So if you don't put all of your assets into your trust, then it may not be effective. So if you forgot about an asset and you forgot to put it into your trust, if it meets the certain probate limits here in Arizona, you may end up having a probate administration along with a trust administration at your death. So that's why it's important to make sure that your trust is properly funded. Another problem we see with trusts they are poorly drafted. So maybe they're inconsistent with your estate planning goals. Maybe there's paragraph references that are missing throughout. Trusts are not a one-size-fits-all document. So if you pull just a random trust off the internet, it may not actually address your specific estate planning goals. Next slide. So trusts are not a magic document. There's a common misconception that a trust is a magic document and that once you've completed, it never has to be updated. So maybe you did a trust 10 years ago and you think you're set. There's nothing that has to be done because you have this trust. And that is very far from the truth. The truth is that estate plans are very fluid. So as we were discussing before, you and your family and your assets will change. So maybe you don't want to leave 50% to your son and 50% to your daughter. Maybe now you want to leave 25% to your son because you gave him additional money throughout your life. Or maybe you want to disinherit your son. Those types of things are fluid and constantly changing. So that's why it's important to review your trust every few years. Also, as discussed previously, the law is always changing. And in addition to the law changing, the practice of estate planning changes over time. So certain planning strategies that exist today may not have existed a year ago. So that is why we do recommend that we recommend to our clients that they have their estate plan reviewed every couple of years to make sure that it's consistent with their current goals and that it's updated based on the current changes in the law. And now I'll open it up to any questions that any of you may have.
Thank you so much, Shanelle. So I do have a couple of questions that came in. If the laws are changing, which it sounds like, of course, they're always being updated, right, and it's pretty costly to put a trust together, correct?
It can be, yes.
Yeah, I guess I'm assuming that maybe that depends on how complicated your trust is, of course.
Right.
Do you suggest waiting until somebody gets a little older in life to get one then, or not necessarily?
No, not necessarily, because if you have a good estate planning attorney, they can create flexibility within your trust document. And this type of flexibility probably didn't exist 10 years ago. So like the trust protector language that I discussed earlier, those are ways that the trust can be adjusted later. So if it becomes irrevocable, meaning unchangeable, and you have trust protector language, it may allow there to be flexibility when those types of laws change. So I wouldn't recommend waiting, but I would recommend periodically reviewing your trust. I know at our firm, we don't usually charge to review your trust if we had previously set up your trust. I don't know what the other practices are here in Tucson, but I'm sure it's probably not too expensive to have your trust reviewed.
Okay. And if you have a trust, is there any reason for you to also have a will then? Or is that not, is that, are you double doing something and perhaps giving different directives in each?
Well, that's a great question. So if you have a trust, you're still going to have what's called a pour over will. So the will allow for any assets that you forget to fund into your trust to be poured into your trust upon your death through probate. The idea is to not have to use the will, but it's there as a backup just in case.
Okay. And I've got a question that just came in asking, does a deed have anything to do with a trust?
So a deed is basically how your real property is titled. So it's important for the titling of your property to be consistent with your estate planning goals. So if the goal is to have the property titled into the trust, you would want to make sure that the deed has the property titled into the trust. And that's part of the funding of the trust. So they are separate, but they do work together.
Okay. Now, is there an amount is there a limit for establishing a trust, a dollar limit?
Not necessarily, but if you have a smaller, so everyone has different ideas of what a large estate is. A lot of clients will call in and say, oh, I don't necessarily have a large estate, but it may make sense to have everything go into a trust because then you could provide creditor protection for your beneficiaries. So there's not necessarily a limit. But I mean, maybe a trust wouldn't be right for you if you didn't have a large estate, and then you could be discussing like what we call a will-based probate avoidance package, where you're having like a will in place and then the beneficiary designations to try to avoid probate.
Okay. And then, so the next part of that question was, what is the smallest amount? And it doesn't sound like maybe there is one to set up a trust. Is there an amount that the least amount that you would do that for?
No, in Arizona, there are limits in terms of what would actually go through probate. So it's $100,000 in equity and real property and $75,000 for the other types of properties, such as tangible personal property, vehicles. So if your assets are under those limits and you don't have a trust set up, then everything's set to go through probate. If it's under those limits, then you could avoid probate. But if it's over those limits, then a probate would be needed. But in terms of establishing a trust, there's not necessarily a minimum amount. And also it's hard to put a minimum amount because there's other values for a trust, such as incapacity planning too.
Okay. And I've got one, it looks like I've got one more question that's come in.
Great.
They're really busy today. Does a trust override costs to beneficiaries? Does a trust override the costs to beneficiaries?
Not necessarily. So there is going to be costs to for administering your trust after your death. If there's a concern about taxes, for instance, then there can be tax planning built into the trust, and you can address that within the trust. But there is administration costs if you do become incapacitated or upon your death. So that's why sometimes a trust is not right for you if the administration costs are going to exceed the benefits of a trust.
Okay. Now, Shanelle, if anyone wanted to get in touch with you, can you provide us with the phone number if they have additional questions again?
Sure. It's 520-664-3420.
Great. So that's all the questions that have come in today. I am thrilled that you were able to be here to sort of discuss more about trusts and when you might need one. So we appreciate you being here, and we look forward to having you in the future for, you know, our whatever comes our way in the new year for elder law. So thank you so much, Shanelle. We love having you.
Great. Thank you, Maya. Have a good rest of your day.
Thanks.